Hey folks, Dave Ceruolo, real estate probate and elder law attorney. In this video, we're going to be talking about 3 important concepts that you're going to need to understand if you're filing a probate petition on behalf of a loved one at the probate court. Don't forget to hit subscribe in the right-hand corner of your screen if you're watching YouTube. Stay tuned. So what's it mean to be a fiduciary? Well, folks, in simple terms, a fiduciary relationship occurs when one person appoints another to act on their behalf. It's like an agency. And with a fiduciary relationship, there is a high level of trust. The fiduciary has a responsibility to act with a high level of good faith and reasonableness when it comes to the stuff or the person of the other. Now, where do you have a fiduciary relationship? Well, if a person completes a simple estate plan and they write up a power of attorney or a healthcare proxy, the agents that are appointed in those documents have a fiduciary relationship to the person, the maker. Where else does it occur? Well, you could have a fiduciary responsibility if you're handling an estate in the probate court. And another term, right, for a petitioner is a fiduciary. And so that could be if someone passes away, or a guardianship, or conservatorship. Dave Ceruolo, CeruoloLaw.com. What happens in Massachusetts if a loved one passes away with assets in their name individually? Well, what happens at that point, folks, is you have to approach the probate court, whether there's a will or not, and file a petition with the court. Now, under the Uniform Probate Code, which is relatively new in Massachusetts, you can file one of two ways. If all of the heirs are getting along, you can file the petition informally. With an informal petition, a magistrate and not a judge is assigned to the case. And a lot of the decisions that are made by the court can be made administratively with no hearings necessary, saving the estate money. Now, if the heirs are not getting along, there's a second way that a petition can be filed, and that's formally. And with a formal petition, a citation is issued by the court, a judge is assigned to the case, and there may be hearings down the road. And what happens at that point is the judge makes the decisions on those matters. Dave Ceruolo, CeruoloLaw.com. So what's the difference between a conservatorship and a guardianship? Well, folks, first of all, a family or friends must approach a probate court in order to file actions on behalf of a loved one that does not have simple estate planning documents in place. Those are the healthcare proxy and the power of attorney. Now, with a conservatorship, the conservatorship is to manage someone's estate. It's a court action, a petition that's filed in the court in order to assist or to take over a person's estate while the person is still alive. So a fiduciary is assigned to the person's estate to care for their money, their assets, their real estate. Now, with respect to a guardianship, that is the care of the person. Now, this is for generally healthcare issues or caregiver issues. And what happens is the fans of a loved one will petition the court in order to be able to make the call for the person physically or medically. Dave Ceruolo, CeruoloLaw.com.